Child custody disputes are often the most contentious in family law, whether they arise in the context of a divorce or a standalone custody action. What's important to note is that the Family Code doesn't even use the word custody. Issues relating to what we commonly refer to as custody are split into two distinct areas. One relates to rights and duties that a parent may have with respect to a child, and separate from that is what the visitation schedule is going to be. The rights and duties relate to, for example, the right to make education decisions on behalf of the children, the right to make health decisions on behalf of the children, and what is often the most contentious issue is which parent is going to have the exclusive right to determine the child's primary residence. In other words, who's going to have primary custody of the child. Courts make that determination based on many factors under the umbrella of the child's best interest. And in most cases, the parent who is a child's primary caretaker is going to be the parent who is awarded primary custody of the child. The other rights and duties, which I mentioned earlier, including the right to make educational decisions on behalf of the child, the right to make decisions concerning the health and psychological care of the child, in the vast majority of cases, those decisions are made jointly by the parents. Both parents are appointed what are called Joint Managing Conservators and have equal right to make those decisions. Visitation, again, is separate. In the vast majority of cases, the parent who is not the primary custodial parent is going to have visitation in accordance with what we call the standard possession order. Under that order, you will have possession of your child every first, third, and fifth weekend of the month and every Thursday, either from 6 to 8 p.m. or on Thursday from when school lets out until Friday morning, the following Friday morning. One of the most common questions I receive from clients is whether they can have, quote, 50-50 possession. This is not common in family law cases in Texas. The Family Code presumes that the standard possession order is in the child's best interest. And if you want to convince the court that 50-50 is in the child's best interest, in most cases you're going to face an uphill battle, and you need to have some compelling facts supporting why you're asking the court to make that kind of order.